Hello, everyone. My name is Edward Stemmer with NM Law, and today we're going to be talking about estate planning. Essentially, what it is, what it can do for you, and what exactly we do in order to make sure that everything is set into place for your family. So I started a while ago with NM Law, and I've been doing exclusively estate planning, and that is essentially what I do here at NM Law. Additionally, we do have probate and we do trust litigation, so generally we can answer whatever questions you may have about any sort of estate issue. So one of the things that we know about estate planning is it has evolved over time. So estate taxes typically followed war times. Originally, it came in World War I, started at a low 10% tax. So essentially whatever you had generally would be taxed at a rate of 10% when you died. So while that is a low rate, it typically evolved over time. It remained at 10% for a while, but again, at the beginning of World War II, it increased steadily over time to 70%. This remained the case essentially throughout the Korean War, and then after that, it began to decline steadily over time until it reached to about 55% during the times for the Vietnam War. Now, of course, it's evolved during that time. It has steadily decreased to about 30% in the 2000s. So that's where essentially it had remained stagnant for a while. And again, it has since increased to about 40%. So that is the current rate. State taxes historically tracked war times. Over the years, it has evolved, starting in World War I at a rate of 10%. During World War II, that increased to about 70%. It wasn't an immediate increase. It increased, of course, over time. So it didn't go from 10 to 70, but just steadily increased. And of course, at the wartime, that is when the rate has historically hit its peaks. It did get reduced, but again, during the Korean War, it rose back up. It rose to 55%. Now, that decreased to about 30% over the years back in 2000. However, it has since risen again and is now currently 40%. Additionally, remember, there are federal taxes and state taxes. Well, currently, California has no estate tax. So essentially, upon your passing, you would not be paying any sort of estate tax to the state of California. We still must pay the federal tax. So all of these federal rates will still apply to you living in California or wherever you may be in any state. So one of the things that we find interesting also with the changing of times is how estate planning has changed. You may have seen some of the cases I'm going to mention. So the first thing the judge mentioned when the attorney forgot that he was on camera, he stood up and the judge famously said, "Counselor, you forgot your pants." Of course, the attorney then immediately sat down, turned off his video, but the damage was done at that point. And of course, the case where the attorney, being older, wasn't necessarily familiar with some of the features, apparently had the kitten filter on. And his line from that case was, "Your Honor, I'm not actually a cat." Luckily, here at NM Law, we are quite proficient with all of the technology. So if you would prefer a in-person meeting or if you like Teams, Zoom, we can always make that happen. So what are some of the ancillary tools that we use for estate planning? There's going to be the trusts, we'll get to that, but there's definitely some things that we have to review first. The first would be that power of attorney. So we have power of attorney for all of your non-trust matters. So if something is outside of your trust, whoever you have nominated as your agent under that power of attorney will be able to manage that property. Now we have healthcare directives. So any sort of healthcare issue that you may have, that would be the individual responsible for making those healthcare decisions. Now, a subpart of that, not perhaps aptly named, would be the living will. That is a document that states, if I am a permanent vegetative state, do or do not keep me alive. Now, there's always going to be a gray area. It's really difficult to actually put words to paper and have some sort of bright line test, the sort of test that we always love in law that states, if I am in X condition, do not keep me alive. But unfortunately for healthcare, that matter is always going to be somewhat of a gray area. And I've had this conversation with my father, who's been a surgeon for 30 years. And even then, it's really difficult to get anything set in stone in terms of, I want this during this exact situation, because it's just never going to be that exact situation. Additionally, there's always going to be assignments of property. So if you want to transfer your car to the trust, which typically we don't recommend, but something like your house, and always the assignment of personal property, so you're not transferring each individual fork and spoon into your trust. Finally, guardian nominations for your children. In the event that both you and your significant other pass, who would you want to take care of your children? It's one of the things that's critically important for any sort of estate plan, that people have some sort of, oh, if something happens to us, things will go well. Well, what happens in that case is the court decides that, you know what, we're going to have the child taken care of by relatives. But just remember, you may not want all of your relatives to be the one taking care of your children. There might be relatives that you prefer. Let's say if you have older children that would take care of younger children, typically that would be preferable. Maybe you want your siblings. Maybe you don't want one of your siblings, and that would be one of the primary reasons. Additionally, you don't want them to go to the state, so always going to be recommended to have family members before anyone else. So some of the things that it escapes me on occasion, just because I'm so used to jumping back and forth between some of the terms. We have the trustor. The trustor is the one responsible for creating the trust. It's also called the grantor, the trust maker. There's several terms, but I try to use trustor just to make sure that everything is consistent throughout. So whoever transfers the property to the trust, gives the property, funds the trust, typically, that is the trustor. Now, other individuals can fund the trust, but essentially, if you do that, you might be giving up that property. So typically, the trustor will be the one who also funded the trust. The trustee is the one responsible for all of the trust property. If you give the trustee something, they will be responsible for managing it. And then the beneficiary, the one getting the benefit of the trust. Now, another important distinction that we must make is the difference between a trust and a corporation. The trust and the corporation, the main distinction there is a corporation is a separate entity from the individual. A trust isn't an entity. You can't sell a trust like you could sell a corporation. So a trust is a separation between legal and equitable title, the legal title remaining with the trust, the equitable title remaining with the beneficiary, the one who gets the benefit of the property. So you can never truly sell a trust, whereas for a corporation, you could sell the trust, or you could sell the corporation, that is, and you could sell all of the shares, you could sell membership interests. It's always just one of the important distinctions there. So what are the benefits of the trust? So we just talked about that separation of legal and equitable title. So the vehicle for the trusts are vehicles for lifetime and on-death gifts. So if you wanted to leave someone property, you would just say, I leave this property to this individual. And that would generally be sufficient to make sure whoever you wanted got that gift when you passed. Now, of course, there's going to be certain restrictions on certain properties. One of the things we'll talk about later is any of the regulated firearms. So let's say if you do have something like a short-barreled rifle or any of those other regulated handguns or other firearms, you would have to have a separate trust or transfer them during your lifetime. As a result, if you do not, your trustee would have to go through the process to transfer it, which might be too much of a hassle for your trustee to deal with. Additionally, aside from all of the tax planning perspectives, one of the things that we will discuss, the most important is the probate avoidance. So for the vast majority of people, probate avoidance is going to be the benefit of the trust. There's also certainty in distributions and making sure your trust property goes to who you want it to, and then timing, because the probate courts are a nightmare, to say the least. And then, of course, you get to see the benefit. So whoever you have as the beneficiaries will then be able to see what exactly they will be getting in your passing. So you'll be able to get that satisfaction there. Now, probate, hell on earth. It can't be said enough. If you're in probate court, you're going to be arguing with a judge. You're probably going to be arguing with other family members as to the division of property. Not only that, based on how much you have, the more you have, the more you will be paying. So this is just the fee schedule. So California has a set fee schedule, once paid to the trustee, once paid to the executor of the attorney assisting with the case. So it is not a fund fee, and a trust would be able to avoid all of these fees. Now, here is a little sample of the trust. So it just takes a look at some of the costs of your estate. So if we look at a $500,000 estate, which I believe the average in California is closer to around $400,000, that would be $26,000 in fees that you'd be paying merely by passing. So having a trust, if you have a $500,000 estate, will save you $26,000 in attorney fees and in fees to the trustor. Again, we go down the schedule, and let's say if you have a $5 million estate. Now, the fee does get smaller per that, and so for a $5 million estate, you're only looking at $126,000, but this is not counting any sort of extraordinary fees. So any sort of difficulties in administering the estate will be in addition to these fees. This is the fee floor, meaning the minimum that you'd be paying for this. So just having a trust in place will allow you to avoid all of these fees. Now, the wills will be the simple document. These will still be submitted to probate court. So just having a will is not going to be a way to avoid probate, but it's still good to give certainty into your distributions just to make sure whoever you have left your property to will receive it. Of course, wills are open to the public. So if you ever have the interest or are bored enough, you can go down to the courthouse and search through people's wills. Admittedly, I've only done that once out of boredom when I was at the courthouse, but still something you can do. And if you do have a will and it goes to the court, people will be able to go and see that. And then certainty in distributions, all of the property to make sure that you have beneficiaries locked in when you pass. If you don't have a trust in place, if you don't have a will in place, the laws of California are going to decide who gets all of your property. Generally, if you have a spouse and surviving children, you would think, all right, everything is going to go to my spouse. But it is much more complicated than that. It requires a distinction between separate property, property earned before marriage or after separation, and then also community property, which is all property earned during marriage. And of course, there's going to be distinctions. So if you receive something during marriage and it's a gift or an inheritance, that would be separate property. So all of these things can greatly complicate an estate. So merely having a will or just having nothing in place is not a good idea. You don't want your children and your surviving spouse to be fighting over the property that you left there. Additionally, there's going to be specific property that you could leave to each individual. So rather than just saying, I want my property to go to this individual, the probate courts will essentially give the executor of the estate, or the administrator, I suppose, in this case, the authority to either sell the assets or give the particular assets to the beneficiaries. And of course, one of the major issues is, let's say if you're lucky enough to have one of your children who are proficient enough to go to the probate court, they don't need to hire an attorney. They are the executor of the estate, the one distributing all of the estate, going to the judge, doing all of the filings. Do they even know all of the assets you have? Do they know where you do your banking? Do they know where you keep the title to your car? Do you know the properties that you own? It's just one of the things that we always have to make sure that the executor or the administrator always know for the estate. One of the things that I always like to bring up is my grandfather. So within his estate, he left a Yeti to my mother. She hated it as a child, but he's going to get the last laugh, because once she finds out that in his will she gets the Yeti under the staircase, it'll be his final laugh there. And of course, the timing. Probate courts are a nightmare. It not only for the cost, but for the timing for everything to be distributed. You can have waivers from the beneficiaries, but that's going to take time. It's going to cost money from the estate. Typically, it's going to be about 6 months. Thanks to COVID, it can be a year or longer. And of course, that could be dramatically increased based on how much you have in your estate. Keep in mind, it's something that if there is any sort of issue in terms of any beneficiaries, what exactly is going to happen. So if people say, Dad left me this, Mom wanted me to have that, it's going to cause significant more issues. Now, some of the types of trusts. These are just a few of the types of trusts, some of the ones that I always like to cover, just the ones that people are generally the most interested in. So you have your standard single trust. This is just the one for an individual. Maybe they are widowed, maybe they were never married, maybe have some children and want to leave their property. Married trusts, another one of the common trusts that we have for individuals that have a spouse. This is the one where typically everything goes to the survivor and then to the children afterwards. And then finally, the third-party special needs trust for revocable trust there. It's a trust for someone with a disability. And we'll go over all these in greater detail later on. Some of the irrevocable trusts and perhaps some of the more misunderstood trusts would be the charitable trusts, which allow you to do charitable giving during your lifetime to take advantage of the favorable tax consequences of that. And then also the first party special needs trust. So special needs trust set up by the beneficiary. Then we will talk about gun trusts and pet trust a little bit later on, just quickly at the end. So the single revocable trust. This is for the individual. And again, we're going to be focusing on avoiding probate and any of those related fees. You transfer all of the property when you pass into the name of your trust. So the way it works is there is a 40% tax on anything that you have over the federal and estate gift tax exemption limit. It is currently $12,060,000 as of 2022. Come 2025, it's going to be reduced to $5 million, as that there is a sunset provision on that. However, remember, this always tracks wartime, and there's no saying whether or not California would be introducing any sort of estate tax. There was a bill that came at the end of 2021 to include a estate tax in California, but luckily for us, that did not pass. So what you would be doing is transferring the property into the trust. During your lifetime, the property will be yours. It will technically belong to the trust. So you as the trustee would hold the legal title, and then you as the beneficiary would hold the benefit of the property. So essentially you have the title and you get the use of. So there's not really going to be any sort of distinction during your lifetime between you as a trustee and you as a beneficiary. The married trust is where it gets somewhat more complicated. The ABC trust, which is perhaps not aptly named, and you would think ABC means easier, but I can assure you, if we consider that there are 100 some odd languages, the ABCs for each one, how many of those could you possibly remember? So typically the A trust or the survivor's trust would be the trust meant for the surviving spouse. So one spouse passes, and then the surviving trust gets their half of the community property along with all of their separate property. Essentially what this does is it creates their own revocable trust, which they could change the beneficiaries, and they will be able to manage simply. The B trust is funded with any sort of amount if there was an estate tax. So if there was any sort of estate tax due as a result of the first spouse housing, you could preserve that by putting into the B trust. The B trust is more limited in terms of the survivor's control and management. So let's say, for example, if you wanted to have the most ease of access for the survivor, you would more likely have either just an A trust or the AC. The C trust is the same as the B, however, it gives much more control by the surviving spouse in terms of access to principal, access to income, and essentially it allows them to have just greater control in taking property out and changing the beneficiaries. The purpose of the B and C trust is primarily to preserve the first spouse's estate tax. So again, if you are at or close to that 10 million, which would be the two spouses' federal and estate gift tax exemption amounts, then that is when you would start thinking about, all right, we're going to need a B trust or we're going to need a C trust. Additionally, if you already have an estate plan in place, one of the things that we see is since the amount was so low prior to 2000, it was under $1 million, increased to about $5 million come 2012, and then has been increasing steadily ever since. One of the things that we would be doing is perhaps getting rid of the B or C trust if you're not anywhere near the current amount of $5 million. Just because the extra administration, since let's say if it was 1990s when it was less than 500,000, then you would want to make sure that you have the option to have ease of administration rather than putting these B and C trusts, because each of the B and C trusts each require an annual filing, since both of them are irrevocable trusts, which require filings for each. Now, the third-party special needs trust is a trust that can be used for the beneficiary. The beneficiary has access to all of the funds. However, they never actually have personal use of it. It's always going to be a trustee who's anyone other than the beneficiary who has access to this. So this would be the example of parents creating a trust for their child that has some sort of disability or the inability to manage funds on their own. There are limited assets or limited ways that the trust can pay out in terms of giving assets to the trustee, giving assets to the beneficiary. Essentially what happens is they can pay for things on their behalf. It's never payments to the beneficiary, just always on their behalf. Now, some of the changes here would be that recently Medi-Cal changed their asset exemption limit, whereas it was 2,000 prior, so they couldn't have assets over 2,000. It is now 135,000, meaning that they would not be able to have, they would be still able to access Medi-Cal so long as it is below that amount. Now, they are trying to remove that asset limit altogether. So essentially anyone would be able to qualify for that, regardless of what they have in their estate. However, that is not the current situation. So it's just better to plan for what the current state is, just in case, for whatever reason, the asset limit is not removed in the future. And again, one of the things that we'll see once we get to the first party special needs trust is there's no need to pay back any sort of debts from the beneficiary since they never truly owned the property. And of course, this is something that's revocable during the lifetime of the grantors. So you could take property out, you could put property in, you could just change the trust entirely. Now, charitable trusts. This is also one of the areas that I say is misunderstood, is because people don't really understand how giving something away to charity could really benefit during their lifetimes. And you might have heard some of the lawyers talking about how charitable trusts can be used to make millions. The one thing they don't really tell you about is exactly how that works and the risks, of which we will go over that. So remember, this is a trust created during your lifetime. It's much more complex than the previous revocable trust that we discussed. Essentially, you can transfer highly appreciated assets into the trust. You can have the trust sell them, and then you would be paying no income tax since this would be a charitable organization, no income tax there. You would get an income tax deduction based on the value of the gift, and then you would be able to offset income produced from the trust essentially for that. Now, of course, again, you would get to carry that forward if, for example, you would not be able to use it all in 1 year. It's something that you would be able to set a stream of income for your life. So let's say if you had a CRAT, which is a charitable remainder annuity trust, you would be able to have that annuity transferred into, you'd be able to have that annuity in the trust paying you for some period of time. And then after that period, it would then go to the charitable organization. One of the things that we frequently see with this is something like highly appreciated assets. So you'd look at real estate, or you could look at cryptocurrency. So if you bought, let's just say, 100 Bitcoins for $10 per, and now you have, let's say, $5 million in currency. So there's going to be a significant amount of gain on that assets. There's going to be millions of dollars in taxes due if you were to sell it. Now, if you put that into a charitable trust and then you sold it, you're not going to be paying any income tax for that period. Since, of course, again, as it's a charitable trust and a charitable organization, no income tax on that. You'd be able to purchase an annuity, and then for a set period of time, you would be able to then receive all of those annuity payments from the charitable trust. Now, there does have to be some likelihood that the charitable organization would get that. So you can't essentially remove all of the assets from the charitable trust. There has to be some likelihood that there will be the remainder for the charitable organization. And that's one of the complexities that we have there. And some of the disadvantages that we discussed, again, if you don't properly administer the trust, then you could lose the tax advantages, and therefore you just transferred your property into an irrevocable trust, and now you get no tax benefits from that. So it's one of the things that we always say, good to do, but if you can't necessarily manage it, it's always good to have a professional fiduciary like a CPA or some other financial professional manage the trust for you, just to make sure you retain the tax incentives there. Again, just very costly to administer over the lifetime if you're unfamiliar with, and the greater assets that might be within the trust if they are difficult to manage. And again, first party special needs trust. We talked about it a little bit. It's a special needs trust created by the individual with a disability. So one of the times that we see this most frequently is if there's a settlement. So let's say if there was some sort of injury and now the individual is going to be unable to function properly for the rest of their life. They cannot earn income reliably for their life. Essentially what happens is they can put their money in this trust and still receive any sort of means-tested government benefits. So let's say in-home support services, Medi-Cal, SSI, they would still be able to receive those services while still having access to all of the trust property. Now, again, some of the cons for this is there's a mandatory payback to Medi-Cal. So any services during the beneficiary's lifetime would generally have to be paid back. There are provisions stating that, let's say, for example, if the beneficiary was to have a revocable trust, that those would not be subject to Medi-Cal payback. However, the main drawback from that is they would not be able to qualify for something else like SSI or any of the other means-tested government benefits. So if really the only benefit that you are worried about qualifying for is Medi-Cal, then this would probably be something that would be unnecessary, as the revocable trust would provide them the same benefit. Again, they're not going to have access to whatever they transfer into the trust. So once you transfer something into a irrevocable special needs trust, it will be locked in there, and it will be locked in there for the beneficiary. Now, some of the special trusts, again, the gun trusts. We talked about it a little bit earlier. One of the reasons that gun trusts exist is just the ease of transferring some of these firearms, particularly the regulated ones, to the beneficiaries. Since, let's say, if you were to pass and you have 100 guns that you have, let's say if you are a collector, and some of them are antiques, you don't really need to worry about registering them or transferring them. Since they are antiques, you'll just be able to transfer them to the beneficiary. Now, if they are one of the registered firearms, so something that you would need to register with the state, so let's say short-barreled rifles or submachine guns, things of that nature, then typically these trusts would be something that you could use in order to make sure the trust would own those, not the beneficiary, and that they would then have access to them. Another favorite for me is the pet trusts. So let's say if you have a pet, you could have a simple provision in your trust just saying, I give $10,000 to my brother to take care of my pet. I give $15,000 to my children, provided they take care of my pet for its lifetime. It can also be more complex. So let's say if you had a disagreement with your children and you said, all right, children get nothing, I'm leaving everything to my pet. They have to take care of my pet for the duration of my pet's life. They have to take it for annual visits. Under no circumstances can they euthanize my pet. And then only after the pet has passed will they have access to whatever remains. Perfectly something that you could do within your trust. That would be a more complex one, however. Or let's say if you have a stable of horses and you want to make sure that they have a stable provided for the remainder of their lifetime, you could leave a certain amount that would be paid for the benefit of those horses to take care of any sort of associated costs. And then lastly, although not necessarily a part of a special trust, one of the important tools that we always talk about is LLCs, corporations, partnerships, and how they have the interaction with the trust. So let's say if you have a LLC and you wanted to assign an interest to one of your children. You can assign the interest in the LLC to the trust, or you could make lifetime gifts to your children. Really, both of them are good options. It really just depends on how you want to retain management of the corporation. Since, again, if one of the, we always see the business owners as the business is another one of their children. So they don't really like to give their children away to someone else. They want to maintain as much control as possible, in which case maybe leaving it into the trust would be the better option. So after they pass, then the children will get it. But if you want them to serve on the board, you can always have them elected, But again, if you just want to give them shares outright, you can always do that. You can also have shareholder agreements that, let's say, you want to give shares of your corporation to your child, but you do not want their spouse to have it. That would be one thing that you'd be able to do there as well. And finally, buy-sell agreements. So let's say if you went into business with your family member, you do not think that if they were to sell, or you do not want them to sell, you can have an agreement saying that you have a right of first refusal to purchase that. It's just one of the options that you would always have. So that is everything for now. If you have any questions, I'm going to be here afterwards to answer those, or you can always reach out to us here at NM Law. Our phone number is 949-253-0000. And again, that will be in the chat afterwards.